we proceed, I want us to pray. Let us pray. Almighty God, who in your wisdom and goodness have appointed the offices of leaders and county assemblies for the welfare of society and the just government of the people, we beseech you to behold with your abundant favor us, your servants, whom you have been pleased to call to the performance of important trust in this republic. Let your blessing descend upon us here assembled, and grant that we treat and consider all matters that shall come under our deliberations in so just a faithful a manner as to promote your honor and glory, and to advance the peace, prosperity, and welfare of our county and those of whose interest you have committed to our church. Amen. We will do, so that we know who is who. We want to proceed to do introduction. I'm Honorable Isaac Chirchir, Chair Ad-Hoc Committee on the Trade Insurance, on the petition of our Trade Insurance Company, and a member representing SOI.
Good afternoon. My name is Rebecca Magut, Vice Chair of this Ad-Hoc Committee, and I represent Queenette Kapsuso Ward.
Chair, honorable members, I am Sarah Malel, member representing Kimumu, a member of this committee and the Deputy Speaker.
Honorable Gilbert Chepkonga, member representing Ainab Kolare Ward, member to this committee.
Honorable David P. Watt Keitany, a member to this committee and also Chair PSM, and also representing Sarkois Ward.
Good afternoon, everyone. I'm Honorable Gilbert Koske, member representing Kiptiret Kipchamo, a friend of the committee.
Good afternoon, everybody. My name is Malamoch Nathan Maina, member representing Segero Barsombe Ward, a friend to this committee.
Honorable Amos Kiptanui, member to this committee.
I'm Honorable Celestine Mutai, special elect member of the committee.
Thank you. Secretariat.
I'm Victor Bergen, the Ad-Hoc Committee Clerk.
My name is Ori Letich, Legal Counsel.
I'm Richard Koech, Sajinata.
Thank you. Our guest.
Good afternoon, everyone. Chair, my name is Boaz Kimeli Bulbul, the County Solicitor and the Acting County Attorney.
So you are the Acting County Attorney?
Yes.
Thank you. In the laws of this country, Article 195, the County Assembly power to summon witnesses. A county assembly or any of its committees has powers to summon any person to appear before it for the purposes of giving evidence or providing information. For the purposes of clause 1, an assembly has the same powers as the High Court 2. 1. Enforce the attendance of a witness or witnesses and examining them on oath, affirmation or otherwise. So the Acting County Attorney and the Solicitor General, you will be under oath. Compel the production of documents. Third C, issue commission or request to examine witnesses abroad. County Attorney, in the premises of this building or this sitting, a county assembly shall, Article 196 of our Constitution stipulates that a county assembly shall conduct its business in an open manner and hold its sittings and those of its committee in public. And that is why, for your information, we are live. So the public is keenly following the proceedings of this House because it was the county workers' petition, and the interest lies with them and also their families. So this petition is live, and we will ask that you respond adequately to issues of this petition. Our legal, kindly, can we have the oath of information with us conducted?
I, Boaz Kimeli Bulbul, do hereby solemnly swear that the evidence I shall give before this Ad-Hoc committee shall be the truth, the whole truth, so help me God.
Thank you. The acting county attorney, on there's a letter dated 11th November 2024, reference UGCA stroke Ad-Hoc stroke volume 1 of 15. The County Secretary, County Government of Uasin Gishu, box start one. Petition to address the county medical insurance through the insurance company. The above matter refers the county assembly received a petition in relation to the Uasin Gishu County medical insurance cover through the insurance company. The county assembly by resolution constituted an ad hoc committee on Tuesday 10th September 2024 to investigate the above subject matter. The purpose of this letter is to invite the county attorney to appear before the Uasin Gishu County Assembly and the committee on Monday 18th November 2024 at 2:30 p.m. at the county assembly premises to shed light on the contract on the above mentioned matter. Shedding light, I think the key word. The attorney should appear before the committee with relevant documentary evidence to address the petition. Enclosed is the petition for our perusal. Kindly inform the relevant officers accordingly. Yours faithfully, the clerk of the county assembly. County attorney, in brief, can you give us in either detail or summary the role of the county attorney in this matter, from procurement to implementation and to contract signing?
Thank you so much. Thank you so much, Honorable Chair. As you have correctly captured, I appear before you, and for the record, I came as the only representative from the office of the county attorney, not as a result of my own decision, but the said office has for 5 officers, the county solicitor, and 4 legal officers. 2 of our legal officers are on leave. 1 is resuming tomorrow. The other one is bereaved, having lost a newborn sometime last week. And the other officer is attending to our mother who is sick, and 1 officer is actually at the office and pursuing, or actually appearing in some 3 matters that were coming up today for mention and hearing before respective courts. And now, to proceed with this petition, to proceed with the infight that I appear before this honorable committee today, we received the said invitation through the office of the county secretary, and we have humbly and dutifully appeared willingly and ready to prosecute this matter before this committee. We've narrowed down our mandate and strictly on the contract that was signed by the user department and witnessed by the office of the county attorney on 22nd July 2024. The county government of Uasin Gishu, through the Department of Public Service, advertised for the subject a tender for provision of medical insurance cover to the staff of the county government in May 2024. And that an evaluation committee appointed as provided for by Section 46 of the Public Procurement and Asset Disposal Act 2015, herein after referred as the Act, was constituted. The said committee sat, and there are minutes to that effect. And the said committee recommended that the Trident Insurance Company Limited be awarded the subject tender, which was done. That on 4th July 2024, the Chief Officer Public Service Management, being the accounting officer, upon recommendation of the evaluation committee and on the strength of the opinion of the professional opinion of the head of supply chain management of Uasin Gishu County, as provided for under Section 84 of the Public Procurement and Asset Disposal Act, awarded the subject tender to Trident Insurance Company Limited. On 6th July 2024, the department requested the Office of the County Attorney to enter into a contract with the successful tenderer, which is Trident Insurance Company Limited. That the said office, or the Office of the County Attorney, as is mandated under Section 7 subsection E of the Office of the County Attorney Act number 14 of 2020, is mandated to negotiate, draft, vet, and interpret documents and contracts for and on behalf of the county executive and its agencies. While performing the said function, the office conducted due diligence on the subject tender process before binding the county government of Uasin Gishu, an act which was done out of abundance of caution, bearing in mind that the function to conduct due diligence is a preserve of the user department, which we confirm that they conducted.
There is, we were, as a committee, I did ask you that briefly there is the role of the county attorney. So from the procedure, can you pick where you come in?
Thank you, I stand guided.
Yeah, that is it. Yes.
Very well. Thank you, I stand guided. Like I was saying, the Honorable Chair, we conducted due diligence on the status of Trident Insurance Company Limited, and we found out that the said company was duly registered with the Insurance Regulatory Authority. And the said information we obtained through their website, which is a public portal and for consumption of information from that authority to the public. The said insurance company is licensed to offer and medical insurance pursuant to license number 1, or in category 1 to category 14, of which in the said listed categories, category number 12 is for the medical insurance. We further proceeded and conducted due diligence at the Public and Procurement Regulatory Authority, and we found that the said insurance company was in good standing, and the said information we obtained from their website. We equally conducted as such at the judiciary, and at the judiciary independently for cases against Trident Insurance Company Limited that could jeopardize the performance of the said contract. Our finding is that we did not find any pending cases against Trident that could jeopardize the performance of the contract that we were to sign. We further demanded to be provided for, pursuant to Section 142 of the Act, the performance security in form of a bank guarantee to be availed by the insurance company, and the same was availed, and it is dated 18th July 2024 from Middle East Bank. We conducted through the user department due diligence of the same performance security.
Chair.
Yes.
I don't know if it is possible because I'm seeing he's reading from somewhere. Is it possible for us to have
Yeah, we need
copy
those
also?
documents.
And also other documents?
If you see your letter of invitation, is that you are in receipt of the petition for your perusal, and one of the requirements that if you have any documents that you deem fit for this committee, you table them. So I am kindly asking you to table the documents.
I stand guided, Chair, but I would really want to confirm, and I believe these are the documents that had been prior supplied by the PSM when they appeared before you. It is basically
So which document are you reading so that members can refer in their files?
Summary. This is just my summary.
The topic of that document?
It's just a summary. It is not even signed. A summary that I'll be done in 2 minutes. I'll be done.
You're asking which document, if you are aware that it was supplied by the PSM.
This is just my summary, which actually I crystallized what I'm presenting before this committee. It's not the document as such. It is my summary.
Can we have a copy?
It's my summary.
Can we have a copy? Do you have it in soft copy?
No, Chairman, I think let's be.
Okay.
Yeah.
I'm getting it from.
So if you have any submission, any document, any reply written that you need, it fits for this purpose, then table it for us. But for your handout summary, that is for you, because you are now submitting an oral reply.
I through the chair, I do not have a document to submit, save for the ones that had already been submitted to this committee, which is actually.
What was that document that you know?
Or rather, I can request that you have the copies and you compare with the ones you have. If you find that you do not have, you can
if you have a document there,
yes, I have.
Just table the document. The clerks will process the documents.
Okay.
Kindly.
Thank you.
Using one copy. Chairman, maybe on your concern, there is no. Yes, it is not bad that you have that summary, but you are referring to very key text of inquiring from the judiciary. And this committee will totally agree with you that if we get correspondence that proves the same, rather than only saying we conducted the judiciary, we conducted the PP, this PPRA or where? Yeah, so I don't know where we will get those information, but your summary is okay from where I sit, and maybe were you also using, did the Department of PSM inform you that there are documents related to such, so that you are referring that the documents that PSM presented?
Now, I do not have the advantage of having appeared alongside them, so I cannot really, and with exactitude, tell which documents. But the document that I have with me is the list of the insurance companies authorized to transact. Here is the list. The one that I referred, that I got it from the website, from the Insurance Regulatory Authority. I can have the same before you, so that for your perusal.
Thank you.
Yes. I also referred on the performance bond from the Middle East Bank Limited. I also have the same, and I would request that we get back our copies, because these are the only copies. Yes, these are the only copies I have in the file. Yes.
Yes, proceed as we make copies.
Yes. I equally have the contract agreement between the county government of Uasin Gishu and the tenderer that is traded in the original form, and I believe we have a copy of this. Yes.
Chair, it is perfectly in order. Let us do a photocopy of that one. Maybe what we have is, we are working in a different world.
This is why you have asked that let it be tabled.
I stand guided. Here is the document. Though I'm referring it during my presentation, I don't know if
we will. Our legal will ascertain the wording, numbering, and whether it is that document that we have with us.
Yeah, I've no problem.
Can table it for the legal to process it?
She can confirm.
I believe she has a copy. Yeah. Proceed. Any other document?
Yes, and I'll proceed. If I pick a document along the way, I'll table. Thank you. So we conducted due diligence on the performance security and ascertained the following: that the bank guarantee was required by section 142 of the Act, and the attendant regulation guaranteed a sum of the 5% of the tender document. The same is captured in the said the document that I've already submitted. The same was a bank guarantee, which would mean that the county government could easily recover the guaranteed amount by way of simple demand. The performance security covered the entire contract period for a period of 1 year. The same can be ascertained from the said document. That upon the lapse of 14 days from the date of notification of award, there being no request for review of the said award to the Public Procurement Review Board by the other tenderers, the Office of the County Attorney, on instructions by the department, through a letter dated 6th July 2024, drafted and entered into a contract agreement. I would wish to table the said letter. That is from Procurement Officer, Public Service Management. The same was...
Do table.
Yes. That is the form of, those are the instructions that we received from the said department, and upon receipt of the said instructions, we drafted and entered into a contract agreement with Trident Insurance Company Limited as provided for under Section 135 of the Act on 22nd July 2024. On the issue of the subject contract management and performance, the Office of the County Attorney purely offers advisory role to the county government. However, the cardinal principle in legal advisory requires that advice is given when is solicited by the user department. In this case, the department has not sought any advice on the progress and legal action over the breaches, if any, in the subject contract. Be that as it may, performance of the contract in procurement as guided by Section 151 of the Act requires that the contract implementation team be established by the accounting officer of the user department. We are aware that such team was established and that the same team has met once and recommended several measures to be done by the department. One such issue is performance of its obligations, including payment of the first installment of the tender sum. In conclusion, Clause 4 of the contract between the parties require the county government to pay the first installment within the month of July 2024. This is an obligation, or what is termed as condition precedent, or consideration in contract law. Procurement entity, before demanding any corrections or specific performance by the insurance, was required to meet this condition. The department is required to have done that to ensure services are offered. On the status of the contract and whether the service provider is performing obligations under the contract, it is our opinion that such performance or lack of it is a departmental function. Lastly, the department, through the contract implementation team stated herein above, should make necessary recommendations that should be acted by the department. That is all, Honorable Chair.
Thank you. Thank you, County Attorney. The matter now refers that we come back to at a stage where the award, prior to award and signing the contract, there is a provision that there should be a market survey. Having the bidders just remained as the only bidder that's now eligible to sign the contract. Did you give a legal advisory on the matter that it must, the procuring entity should do a market survey to ascertain the actual position of the documents and performance of the company? case in example is the listing of various facilities that could provide medical services to the people, to the workers of Uasin Gishu that were listed. But in reality, that the same company did not have any contractual terms with the facilities as at the date of signing of the contract. An example, one.
If you permit me, with your kind permission, Chair, can I answer so that I do not forget?
I was giving you an example. I'm not asking, it's only one question structured. One is Eldoret Hospital and MTRH that were listed by the to the procuring entity, but could not, they don't have any contract up to date with the said facilities. That is one list, and I'll give you your request. I'll grant you that request to answer that one. That whether really you ascertained the actual position other than the paperwork that was given by.
Chair, can I fertilize on your question?
Not really, honorable member, but if you have an issue, a question that is attached to that, you can ask that question, and he has requested that he answers that one, so that we proceed with about 3 questions or 4 questions, and we proceed.
Thank you, Chair. I think one of the things that I have noted is the honorable, the solicitor, has actually said that he did the due diligence and actually checked on the company background. One thing that I've noted is, did you check that maybe they don't do medical? Maybe the IRA only give an assurance maybe when they are doing the insurance point of the insurance side of it. Did you confirm that they are doing even medical or life assurance? That is what I wanted you to come clear. Thank you, Chair.
Proceed.
Thank you so much. And Chair, if you permit me start and answer the first question on market survey. And Honorable Chair and the entire committee, the function of the Office of the County Attorney is to draft an agreement which we received instructions from the department upon finalizing the evaluation. As of today, Honorable Chair, we do not have instructions, and we did not even receive instruction from the department to assist them to ascertain if market survey was necessary or not. So as such, I would respond by saying we were not given an opportunity to give an advice on the issue of market survey.
By the procuring entity?
By the user department, which is the
procuring entity.
Yes, we didn't receive such instructions.
Thank you.
Number 2, to answer on the list of hospitals, in our endeavor as the Office of the County Attorney to protect the interest of the county government and by extension the residents of county, of the resident of Uasin Gishu County, we drafted an agreement which at clause 15 which at clause 15 we brought a term and a condition of the contract to the extent that reads the service provider commits at all times. Now, let me start from they said section 15, it was our action as the Office of the County Attorney to protect the users or the beneficiaries of the cover by bringing in this section which provides that the service provider commits to at all times during the subsistence of this contract ensure that all the facilities in Annex 2 of the tender document provide medical services to the county staff. Annex 2 listed the hospitals, which actually, in your question, comes and I'm now learning that the said hospitals does not provide, or they are not in good terms with the insurance. But at the time of drafting this agreement, we went out of our way and contemplated that we do not want to enter an agreement with an insurer without not knowing which hospitals are these that will provide medical cover to the great people of this county. And we provided for that list, which Eldoret Hospital is inside, MTRH, all the top-notch office and hospitals within the county are therein.
And are you aware that the service provider did agree that they have an agreement with the said hospitals in the contract as per section 15?
Kindly come again.
Can you read section 15?
Section 15, clause 15 provides that the service provider commits to at all times during the subsistence of this contract ensure that all the facilities in Annex 2 of the tender document provide medical services to the county staff.
Yes.
Yes.
Now, we come to this. Can we read the feedback from the facilities so that you can give the advice on the way forward with this? One, Eldoret Hospital. I'll read two facilities on behalf of the other facilities. And this is the date of contract.
Point of order, Chairman.
What is out of order, Honorable Member?
Thank you, Chairman. I am addressing you, Chairman, in the manner of questioning. That, Chairman, we were still at the preliminaries. We were still realigning ourselves with the functions of the Office of the Attorney General. But County Attorney. Chairman, you have gone further. You have gone further to now dwell in the matter.
On the subject matter.
On the subject matter. I still had a question before we go that deep. That I wanted to know the role of the county attorney in respect to this contract. And he has said, one, I heard that the office of the county attorney does not go to departments hawking their services, and that you only respond upon invitation.
Not invitation, remember, in legal we say solicitation, when they are solicited.
Yes, let us appreciate the English.
Yes.
Now, county attorney, what is your advice on the paperwork between the procuring department or user department and the office of the county attorney? What is your submission before we go deep into the contract? Was everything done according to the paper? Or you have somewhere where you will say, if this was done this way, it could have been better?
Thank you. Through the chair, at the time, or during the process of evaluation and at the time of reducing the same relationship between the tenderer and the procuring entity, the process that led to the award of the tender was above board. It was above board.
As in, can you expedite on the above board?
Every legislation that plays its role, and in particular the Public Procurement and Disposal Act
was adhered.
Yes, it was strictly
followed. Adhered to.
Yes, and it is only at the implementation stage that the hiccups started,
and that
is why the law contemplated such a scenario and provided for what we call a contract implementation team or committee, and that is now the committee that is mandated to link the procuring entity and the tenderer, and if there are any issues, they bring it to their attention as the office of the county attorney in form of instructions.
Thank you. Proceeding on, Chairman, following that above board issue, I just wanted to ask that while submitting all the necessary documents during bidding for that contract, is it a requirement that they submit factual information during and in the process of tendering and awarding that tender? Is it a requirement that they submit factual information?
Through the chair, I would not go to that province, and with all due respect, for reasons that is purely the preserve of the evaluation and evaluation committee, which at that time I did not sit, and as such, and which meant as respect, honorable member.
Was there legal representation in the evaluation committee?
No, it's not a requirement.
There wasn't.
It's not a requirement.
Honorable member, I think you are to, you've had your answer, and I think honorable member from Sergoit, kindly come.
Maybe on that, now that they are not part of that evaluation team, I don't know, is the report from the evaluation team important before signing the contract?
It is purely a function of the procurement, and it is climaxed in an opinion, professional opinion by the procurement officers. You realize that from our end, we are legal officers. They are procurement experts. They give us an opinion that this was above board, and we act on the instruction of drafting that agreement. And in this particular scenario, I was purely invited, honorable member.
Thank you. I can get you.
Maybe
honorable
chair,
members.
while
Yes.
it's still on that issue, maybe the question is, what are the important documents that, maybe the office of the attorney, county attorney, which documents are very important that maybe you are supposed to go through before you sign?
Thank you, honorable member. What happens in practice is that we receive a tender document. We go through the tender document and reduce the tender document into a contract. If the tender document provides that security is needed, that is what we demand, and that is what we demanded in this matter.
So in this case,
order must address the chair through the chair, please.
Through the chair.
The member from Sergoit is still on.
On that one, chair, there is a clause whereby in that contract whereby the insurer or the person that the
service provider,
provider was supposed to provide evidence to show that he can provide services to the county staff, either in Eldoret Hospital, MPRH, and the rest. Was there anything showing that they have a contract with those hospitals?
The tendering entity, in this particular case, Trident, having won the tender, in our wisdom, in our collective wisdom as the office of the county attorney, we contemplated a scenario where some hospitals will complain against, and this is as a result of, as history, the previous medical covers. So to safeguard the interest of the county staff, we made it a condition that they give us an extra of hospitals, and that is what they give us. At that point, we could not really ascertain if they will perform or not, unless the contract starts running. That is the point now where we'll say, hey, and this honorable committee has been informed of the same, that there are hitches. That is the only point you can ascertain.
Thank you. Thank
What
you.
remains is purely
Thank you.
speculative.
I want to I'll give you honorable member. One is that the county attorney and the legal department of the user department is that you are satisfied with the contractual terms on the tender document as you ended up reducing the tender document to a contract. You are satisfied with all the opinions, the professional opinion, the evaluation committee opinions. You are satisfied with that. Two.
Yes.
Two, your other purpose was to advise on post-contract signing, whereby is it you advise that you advise the procuring entity to form an evaluation committee, implementation committee, not evaluation committee, an implementation committee.
It
on
is
whose advice?
It is not our advice. It is a provision of the law.
It's a provision of the law.
Yes, it's a provision of the law.
A committee on implementation is due formed.
Yes, it is a provision of the law.
In that respect,
yes,
have you had time to get the report of the committee?
Now, what happens upon the say and when that committee sits, their mandate is to check on the progress of the implementation of the contract.
That's it.
If there are any hitches or any breaches on either on both sides.
On both sides, yes.
Yes. They recommend through the accounting officer of the department,
yes,
who will write to us seeking advisory, legal advisory on the same and way forward.
Yes.
And as of today, Honorable Chair,
yes,
we've not received any instructions from the department.
From the accounting officer,
yes,
which is the chief officer,
yes,
in that department.
We've not received
to date.
Yes.
I want to bring you to notice on the following dates that on 12 of August 2024 at the county chambers, the committee of implementation did sit, and the following members were present. That is Nathan Koech, the chair, Boniface Cheruyot, legal counsel, and we will require to know Sharon Molongo, member, Wasike Wanyama, admin officer, member, Justin Rotich, HRO, Alex Sabai, HRO, Evans Kimutai, HRO. Agenda, report from the tender committee, implementation status of the staff medical cover, recommendations, and any other business that will arise. Report from the tender committee. The committee received a brief from the 3 members of the tender evaluation committee and staff on staff medical cover, where it was reported that the tender advertisement attracted 6 bidders by close of submission date. The bidders included AR, First Assurance Limited, Madison Insurance, Star Discovery Insurance Limited, Kenya Alliance Insurance, and the Truden Insurance. Upon initial evaluation, 2 bidders, namely First Assurance and Star Discovery Insurance, were found non-responsive and were therefore dropped, leaving the other 4 bidders to proceed for the technical evaluation. Kenya Alliance and Truden Insurance made the pass mark score and were considered for financial evaluation, where Truden was found to be the lowest bidder and therefore being the successful bidder. Subsequently, Truden Insurance was contracted by the county government via contract number CGU/PSM/T/07/2023-2024, dated to 2nd July of 2024. The committee unanimously approved the tendering process was above board, and as agreed, you really also obliged that it was above board, and that the contract terms were well negotiated by the county. Implementation status, that is where now the gist comes in, of the staff medical cover. The chair led the team in reviewing the performance of Truden Insurance Company for the period July 23rd to August 11, 2024, taking into consideration the terms and conditions of services as provided in the contract. The committee's noted with concerns a number of challenges experiencing at the initial phase of the contract implementation. The committee highlighted the following issues to be addressed by the insurance: that the staff cannot access services in majority of the facilities provided by treaty and insurance company. And with that, we have letters from those facilities that they have said they don't have contracts. Lack of service from major hospitals such as St. Luke's, Eldoret Hospital, Real Hospital, and Top Hill Hospital has affected staff medical services. Currently, staff receive very limited services in Life Care Hospital, Avenue Hospital, and Palm Care Hospital. This is in contravention to Section 15 of the contract, which states that the services provider commits to all times during the subsistence of this contract ensure that all facilities in Annex 2 of the tender document provide medical services to the county staff. That on Friday, 19 August, the patients who is a child name withheld to the principal members who are our staff visited Life Care Hospital for treatment, which required an operation. The total cost was Kenya shilling 200, but the insurance approved only 110,000, despite the inpatient limit for both parents being 1.5 million each. The patient was turned away from the hospital despite the county intervening on the matter. Failure to facilitate treatment goes against Section 14 of the contract, which states that all services, including chronic and pre-existing condition, shall be fully covered. As per Salaries and Remuneration Commission SRC, limits, and there shall be no sub-limits on any conditions. There has been a concern over time taken for the insurance to approve requests for hospitals for staff treatment, which has led to the officers and the county follow-up with insurance for approval. Despite these follow-ups, the insurance has not resolved the matter, as some requests take up to 5 hours to get feedback from insurance. Example, 12th August, Evans Kiprotich, a staff reported to Life Care Hospital at 12 noon for treatment. He was asked to wait approval for treatment and had to wait the whole day. This led to our officers intervening by making a follow-up with email at 31 hours for the patient to be attended. Copy of email attached. The failure to respond on time goes against the Section 23 of the contract, which states that the service provider shall strictly adhere to the target set in the tender document, include timely response to approval request from the hospital. Section 26 of the tender provides that for the inpatient services, the service provider shall consider a facility that is NHIF accredited. Contrary, the only inpatient facility currently accepting Trident insurance cover is Life Care Hospitals, which is not NHIF accredited. This is affecting staff treatment and is against the provision of the contract. That the service provider should not wait for follow-up by the procuring entity in order to facilitate treatment whenever county staff visits the hospital. Committee recommended the following: that all the concerns raised above be addressed by the service provider immediately for the smooth running of the scheme, that the insurance should consider having a designated care manager to handle county staff medical scheme, that the county should meet its obligation as per the contract, including making payment due for the service provider on time. So the purpose of this letter is to qualify your assertion that the implementation committee, having had the report, the accounting officer, having had the report from the implementation committee, and you can affirm from this house that the report went to the accounting officer, and the accounting officer is required by law to write to the legal for advice. Are you in receipt of any communication from the accounting officer?
In the negative, we've not received any communication as a result of the said sitting, which was done on 12th August, and the said minutes signed on 21st August 2024. We've not received any communication
seeking legal redress.
Yes, we've not received any communication from the user department.
Honorable members, on this matter, has there been any legal has there been any solicitation of legal advice from the department, the user department, on the matter of Trident since the contract was signed?
Chair.
For the record, Honorable Chair, we've not received, apart from the day we received instructions to draft
the contract,
and which we diligently performed our mandate, we've not received in writing
any
other communication, instructions, or any other form of any directions that the user department needed from us.
Chair.
Thank you.
Chair.
I want to honorable member.
Thank you, Chair.
From Jeptiret Kipchamo, and then we come to honorable.
Thank you,
DS.
Chair. I think the acting attorney is under oath, and if I could get back to the participants who were there at that time, one of the person was from legal.
That is where we are coming.
Yes. So it means they were represented in that implementation committee. Does it mean that if you could read in fact it was number 2, if I could remember you reading. Number 2 was
let me clarify for you, for answered Boniface Jeruyot, legal counsel, who is a member. Does he sit in the, is a departmental counsel or sits in the attorney's office?
For the record, Honorable Chair, Boniface Jeruyot is our county legal counsel, sits in the office of the county attorney, and sits in this committee. The sittings of the committee and the deliberation of the said committee, the outcome of that committee is purely for the consumption of the accounting officer of the PSM, not for the office of the county attorney. The said legal counsel sits in that committee. Any other deliberation, any other transmission of deliberation of that committee is done by the accounting officer, in which in this case
is the chief officer, public service,
and she has not done such communication to our office.
Exactly.
He sits as a member.
Well clarified. Honorable.
Maybe through Chair,
Yes.
I just wanted to know the role of that legal officer in that.
It is coming clear,
but now
honorable member, that
they say it is a member. I'm still wondering why that person. Why is it that he is part of that team?
honorable member, I think
there is
a procedure. The legal counsel has, the acting county attorney has just explained that matters of implementation committee ends up with accounting officer, which is the chief officer public service management, and from any recommendation from the implementation committee is forwarded by the accounting officer of the department to the legal team, and that is where it has not ended in the office of the county attorney. The matters have not ended because of non-communication from the accounting officer in the department. So I think we are getting something, honorable members. You are come to honorable raise the question so that we can go to honorable Chepkonga.
Thank you, Chair. What I wanted to know from legal for purposes of this committee, and I'm getting it very well, that there are parameters in this case. They are only executing an agreement which parties have already agreed, but they are coming before them. But the only thing that you have confirmed to this committee is ascertaining the security, because you are engaging the county in such a matters to make sure that the contract is within, it is followed to the letter. Maybe what I wanted to know from legal, that is it really a requirement that you ascertain if a service provider has bidded to provide certain services, and of course they meet the threshold of whatever areas that you have also provided us with evidence. Is there any other thing that does it mean that we cannot go beyond that, but that person in future, if they infringe any of those laws, watakuwa culpable, such that now the list that Trident Company provided for you as the hospitals, and it was not the true position, where does that leave us? Is it a legal matter to be handled, or it is something to be left
Thank you. So that you respond, let me add this, bring you to speed, that from the Department of Public Service Management, having the accounting officer, having not sorted your help in this matter, also wrote to Trident, and she has written to Trident not once, just twice, and the first, I'll read. The manager, Trident Company Insurance Limited. Dear Sir, Madam, medical profession performance. The above subject matter refers the medical insurance cover starts its operation on 22nd July. Since the inception, the county has had some challenges in administration and performance of the medical insurance cover. This prompted the Medical Insurance Monitoring Committee to have a meeting which was held on 12th August 2024, and the following attached challenges were observed with recommendations made. Kindly address the mentioned challenges as soon as possible so as the staff can continue enjoying the medical services as per the contract agreement. To this, there was no reply from the service provider. There was no reply to that letter. Then there was a follow-up letter.
With your kind permission, can I know the date when the said letter was written or drafted?
That letter was drafted on 26th August 2024. The second letter was dated 18th October 2024 in reference to UGCA PSM stock 2024 412. The manager insurance Trident Company. Dear Sir, reminder on medical professions performance. This is a follow-up on the same. The reference is made to the letter PSM 2024 stroke 368 dated 21st August 2024 on the above subject matter. The issue is raised in the above letter addressed to the management of Trident have not been resolved to date. Furthermore, our efforts to reach over to your office through phone or email have not been successful. Kindly provide comprehensive feedback on why the county is still unable to effectively use the cover in various hospitals. Other concerns raised in our letter. We will appreciate if the above feedback is provided. To date, as per the sitting of the PSM.
May I know, Honorable Chair, if the said letters were copied to our office?
The letters were copied to DAPSM, County Secretary, County Attorney, Director Supply Chain Management. CCM member, County Secretary, County Attorney, and Director Supply Chain Management. Were you in receipt of these copies?
If they are, I cannot confirm or deny.
The receipt.
Yes.
If you have never read, then you have not received. Have you ever read it in either in email or in soft copy, any other soft form, or in hard copy? Are you in receipt of this?
Again, Honorable Chair, I'm saying I cannot confirm or deny receipt of the same.
Honorable,
if you permit me answer the question that was raised by the Honorable Member.
Yes, so that she concludes. Hold your horse, Honorable Member.
Now, you asked the question on whether the said service provider, for example, he gave a list as Annex 2, and the said list and the said hospitals has not performed. To answer to that question, honorable member through the chair, is that pursuant to Article 16 of the contract which we drafted, it provides that parties agree that failure by the service provider to ensure that medical services referred to in clause 15 shall constitute a material breach of contract. For the record, Honorable Chair, we do not sit on the fence during the implementation of this contract. Such a breach and the said letter, in my opinion, to the insurance, and if you've perused this contract, it was witnessed by Boniface Cheruyat,
Yes.
and sits in the implementation committee. So what ought to have happened as a matter of procedure, though procedure and tradition, the said accounting officer ought to have wrote to us as a result, directly, as a result of the said breach. Though the recommendation does not talk of a breach, then we now do a demand to the said company on the said breach.
So in this matter, whereby you have now the communications and it's copied to you that the performance is wanting, and it is clearing now that to date the said hospitals, majority of the hospitals, have no any material contract with Trident Company. What is your position as the county attorney?
So the position, Honorable Chair, is provided for under clause 41, which provides on settlement of disputes. We do not want to really subject or we want to protect the county government from a legal risk. So in the provision of the said and the clause, the first thing to be done is avoidance of conflict. That is done by the contract implementation committee, yes, through meetings with the service provider. That is one. Number two is resolution. Partly again, you'll find that in the said letter it was purely for avoidance of conflict. It had not crystallized
into
through the recommendation of the contract implementation committee into a conflict.
Yes.
That is now when our duty kicks, or that is what will trigger our mandate and strive to protect the public resources that has been used in this matter.
And in the communication hearing, do you see the standoff?
Pardon?
In the said communications that have not been adhered by the service provider, and in absence of contractual terms with the said facilities, do you find a breach of contract?
I would say it is gravitating to that position, though what what has been
then
taken,
what is the legal
what
procedure
has been taken
in such a scenario? What is the legal procedure provided in the contract?
What has happened actually, I believe, is mitigation or avoidance of that conflict.
Yes.
And that is why they wrote to them. And if they are not responded to this date, it will be now the mandate of the user department to instruct us, and we will act swiftly.
So you are waiting for a trigger?
We do not wait for trigger
from the user department.
We do not wait for trigger.
Yes.
We await for instructions
from
the
yes.
department,
the user department.
Yes. Section 7 of the Office of the County Attorney Act number 14 of 2020 states that we act on instructions of the county executive.
You don't forage on it.
We cannot instruct ourselves. We cannot instruct ourselves.
So upon that, to date, you have not had any instructions to that effect?
We've not received any instructions on mitigation of any material breach, and if the said instructions comes, we will ably defend the county government.
Honorable, yes.
Chairman, maybe to complete on the period, from a legal person perspective, what will you advise this committee, maybe, because what period of time do we need to give this committee to do love letters, or I don't know what letters, that they are not being responded to, yet the consumers are suffering. They are not getting the real services. Would you advise us that we instruct them to do what are they supposed to do really?
Pursuant to clause 41, there is a period of 30 days.
Only 30 days.
30 days. It provides that any dispute arising out of the contract which cannot be amicably settled between parties within 30 days shall be referred by either party to the arbitration, and final decision of a person to be agreed between the parties, and the failing between the parties, failing agreement to concur in appointments of the arbitrator shall be appointed by the chairman of Chartered Institute of Arbitrators. So we have a period of 30 days.
The next course of action is now the case might land into the arbitrators.
Yes.
So that is where from here it should land there.
Yes, that is the direction
and
that you take.
And where will you be getting instructions from? Can the department do the instructions directly?
What the department does, they write to us, we issue a demand notice, which we can deem the one issued by them, and considering that it was issued on the 18th, the last reminder was on 18th October, today can be the last date, then from there, we engage, we now escalate the matter to an arbitrator.
Okay. Supposedly, this house on its oversight role do instruct on the interest of the petition, your office of legal office, to look into the matter. Shall it bear the same meaning as instruction from the Justice Department?
We are alive to the fact that this committee exercises a constitutional mandate.
That's it.
And nothing stops us from acting, because your communication will run through the county secretary.
Exactly.
The county secretary is part of the executive. Any information we get from the county secretary suffices as instructions.
Thank you, Honorable Member. Honorable Shadow. Then we come to
thank you, Chair. I don't know why. I'm still interested to know why Boniface Cheriot is not here with us today. I know he gave us in general the reasons why the other members didn't make it to come. I think through you, Chair, it's good because I'm seeing Boniface Cheriot is the one who witnessed the signing of the contract. He is also part of the team of the implementation committee. Maybe can we get it clear? Is he the one who was briefed, or maybe so that we can get to understand? Maybe it is a design. It was designed not to have Boniface Cheriot here.
Yes, through the chair, and for the record, Boniface Cheriot and reports to me. I am the authorized and the accounting officer of the Office of the County Attorney, as the principal assistant of the County Attorney, sitting as the County Solicitor. So anything that he does so under my authority. For the reason as to why he did not appear before this honorable committee today, that it is that on 5th November 2023, while his wife was in the process of delivering, he lost a baby. May the soul of the infant rest in peace. Is today immediately upon the said when they say
I think
when it occurred,
after that point I don't have any other issue. I just wanted to know.
We oblige to that.
Thank you. I actually gave him. He took his annual leave, which will be over after the expiry of.
Thank you, honourable members. I think also we are very much aware that the Boniface sat on the Committee of Implementation, and the report to the Committee of Implementation does not go directly to the office of the county, but rather goes through the accounting officer of the department, which is the chief officer of the department. And to date, that letter has not reached the office of the county for advisory opinion. So, honourable members, you're finding that there are matters that does not move because many a times it has lapsed at the accounting officer's desk. The only thing I was a bit scared is the matter of these letters that were copied to you from the accounting officer and the assigned department, which you have said you are not really, you cannot really ascertain whether you received or not. That is on our answer. Thank you, honorable members. Honorable Chepkunga, you come on.
Honorable Chair, I just want to mention a matter of concern that they say 2 letters written by the Committee on Implementation. They were copied to the office of the county attorney.
For information, honorable member, the letters were not written by Committee of Implementation, but the Committee on Implementation gave a report. They gave a report to the accounting officer of the department, and the letters to Trading were letters from the accounting officer to the Trading, not the Committee of Implementation. So the 2 letters are letters from the user department, and that is from the accounting officer.
So the question is, Chairman, following the 2 letters, they were copied to the office of the county
attorney.
For what purpose, if it is not to participate in the process? That is number 1. Because when a letter is copied, then it means that an action is required from you. Yeah. What action did you surface in response to those 2 letters? Number 2, and this is a point of concern, Honorable Chair, that all the officers who were involved in the execution of this contract seem not to be appearing in this committee. And there are reasons, and many. You remember the Chief Officer, Public Service Management, at that time, Mr. Ambrose Tarus, conspicuously did not appear before this committee. There is this Boniface Cheruyat. Reasons servicing us well, but still, he's not here to help us today. My question to the county attorney. You sit here not just as an employee, but an equal member to this county. You are a beneficiary of the services offered by county government of Uasin Gishu. We have established that Trident Company does not have contractual agreements with major facilities in Uasin Gishu. We have established that the demand for survey during evaluation was oversighted. It was overlooked. And all these are happening, and you are the legal advisor. As the legal advisor, you want to sit outside the purview of this community to say, I am waiting for instruction. I want you to give us a legal opinion as a beneficiary of the services offered in Uasin Gishu, that may the people of Uasin Gishu perish in eternity because no one has sought services to your office.
Yes, County Attorney.
Honorable Chair, I confirm that I'm a beneficiary of the said cover, and I'm consumer, and I'm a principal. I'm a principal and member. Actually, there are times that I've personally not felt well for that period, and I have consumed the services of the said service provider. On the issue of me giving a legal opinion, on the soundness of the said service provider, I believe that if this committee formally seeks my opinion on the same legally, I will provide. But on being a consumer of the services I've consumed, and it is in public domain that I've been hitches, but on the very day that I consumed the services, from where I sit, I did not suffer any hitch. Unless and I am to request this committee, if we can get data from the said hospitals indicating to us the people who have enjoyed services, then we would get proper information.
Madam Chair.
Yes, Honorable.
I still have a question. That professionally you will wait for instruction from the officers or from the executive for you to act on their behalf. This is a contract between these two parties, and the contract is for 1 year. This is not Nguzo Committee 5 year. This is a contract for 1 year, which means a failure to deliver service within 1 or 2 months is a great injustice to the people of Uasin Gishu. You want us to dilly-dally, write love letters until the contract expires. You want us to engage in cat and mouse game, but we have very limited time to prosecute this matter and come to a conclusion so that we save the residents of Uasin Gishu. What amounts to breach of contract? That is a question, not an opinion. What qualifies to go to an arbitration, and what qualifies to go to an outright termination of a contract? In this case, if you consider that they lied by giving us a number of facilities, which in this case, and we have confirmed, they don't have contract with those facilities. How would you treat that one? Is it a love letter relationship to address that issue? Does it qualify to go to an arbitration? Or this is a breach of contract and that it leads to termination?
Well put, Mheshimiwa.
Honorable Member, through the chair, to answer your question sufficiently, is that I do not want to usurp the powers of the Contract Implementation Committee. Contract Implementation Committee can sit anytime, even tomorrow. And if they form an opinion that there is material breach, and the said information is conveyed to our office, we will invoke Article Clause 42 of the contract, which provides on termination of a contract. And there are various grounds for termination. Which lists from subclause A to clause F. If they give us, because if today, Honorable Member through the chair, if today I wake up in the morning and write to the insurer that we've terminated their services, the following day we'll have a court order reinstating their services through a judicial review, and I'll be accused of abuse of office. There are structures in government, and it is upon the user department, and if they do not really get it well, they can write to us to assist them, and we will definitely do so. It is our function. We draw a salary to perform as such. Honorable Chair, anytime we can invoke clause 42 in the best interest and to protect the great people of this county. We can move to court and compel them perform their function to the extent as provided for in the tender, in the contract agreement. As the office of the county attorney, we are ready. Thank you, Honorable Chair.
Do you believe that we have enough reasons to invoke Section 42, Clause 42?
From the narration of the contract implementation committee, where one patient approval was 110,000 instead of 200.
Yeah, at 101,000, not 10,000.
Yes, 101,000 instead of 200,000.
110,000, 110.
Yes, 110 instead of 200.
Yes.
Then that one tells you that in performance, if this 200 is 100% and 110, then 110 is 50% in their performance.
Yeah.
It is not something appealing to the eye. And if we get a report from the said committee today or tomorrow on the same scenario, it is material breach.
That is it. On the another matter of breach, it's clearing that on SRC recommendations and in their provision for to stand with the SLC, they ended up introducing some limits. What is your advice on that?
If the said introduction is outside the contract agreement,
yes,
the pre and post contract negotiation that I believe was done by the user department, it automatically amounts to breach. It is now the function of the said committee to back the same and the said breach with facts. And as the office of the county attorney, will be fully armed to defend the procuring entity.
Honorable Des.
Thank you very much, Chairman. I can see from the legal advice that there is somebody who is taking us for a ride. And I don't know whether they are still negotiating for the improvement of terms of service, for the service delivery, or they are dilly-dallying for what. Because county attorney, maybe to confirm to me, I didn't hear very well. Must we go to mediation, or we can go directly to breach?
What is the best practice you feel?
Honorable member, through the chair,
in such a matter,
I would refer you to clause 42, which provides on termination of the contract, and it is twofold: there is termination by the procuring entity and the termination by the service provider. The procuring entity, if you permit me to read verbatim, the procuring entity may terminate this contract in case of occurrence of any of the events specified in paragraph A through F of this clause. In such an occurrence, the client shall give not less than 30 days written notice of termination to the supplier, and 60 days in case of the event referred to in clause E. A. If the service provider does not remedy a failure in performance of the obligation under the contract within 30 days after being notified, or within any other period as the client may have subsequently approved in writing, if the let me come back again.
Sorry. Yes.
If the service provider does not remedy a failure in the performance of the obligations under the contract within 30 days after being notified, or within any other further period as the client may have subsequently approved in writing. B, if the service provider becomes insolvent or bankrupt. C, if the service provider in the judgment.
That is enough legal, because we know we can read. In this case then, Trident was here in the morning. And they are saying that they are still even doing agreements with hospitals to date. Yeah, there are, up to this day. Can we term those ones are part of the breach of contract? In the first place, they came listing the hospitals, knowing very well. Will we now admit in this period of 30 days to comply with ABCD? Or that was an illegality straight from day one? Because they were talk to us today talking about still doing agreements.
In that respect also?
Yeah, with hospitals.
Since July, we are now heading to December, half of the year, where the performance of the service provider is still not yet up to date. It is the service to the people of Wasingishu and the workers of this country. Do you find it still a matter that should be entertained further by our department, or we go the legal way?
Nothing stops us from invoking the said provision. Having said that, and from the said officers, nothing stops us from invoking the said section. We can act accordingly.
Thank you.
Chairman, maybe Wakili to complete on that last part. Is that right for Trident to tell us at this point of time that they are still signing agreements with hospitals that they provided for us? Is that correct?
We can have that as, we can have the said, through the answer, we can have the said communication as a form of admission and will aid us in prosecuting this matter.
Because a case example, Eldoret Hospital have not renewed the contract with Trident since 2020? 2022.
22nd, 2022.
Referral since 2021.
Yes.
They have secured a tender to give us services, and yet they used false information only to date find that they are telling us today that MTRH is signing.
They said as of this evening,
MTRH will sign the contract.
And we are really serious on the insured sums, because at the half year, the insured sum, utilization of the insured sum for the benefit of members, the provider will duly be serviced with a total sum of 240 million for that matter, while the users have served for 6 months. That is a clearing conmanship and fraudulent way of obtaining finances through inefficient management of Trident. Members, as of now, it is very clear. I want members that we are almost closing, and I want to ask members, before I ask our legal to give his final closing remarks, I want to ask members whether they have concerns still to raise, so that it's handled and we conclude the matter. It's very clearing that the people of Wasingishu are not enjoying what they ought to have.
Thank you, Chair. My concern is having had maybe the legal officer on the issues of terminating the contract. And I've come to realize that the main role of the department is to give advice to the county government, especially the departments. I don't know now, Chair, if the department, the user department, in case if they will keep on remaining silent, as the county attorney, what is your advice? And that is for the benefits of the county staff, including yourself.
Thank you, Honorable Member, through the Chair. And since we have a legal representative at the said contract implementation committee, who is equally and ably fit, and who is actually ably and fit for the said work, if we find that there is a delay from the user department, I would inform, he would definitely write to me on the same, which will now give me a ground to communicate with the said officer, which is actually the accounting officer, and to guide him now. Because sitting in that committee is actually in the best interest of implementation of this contract, which we performed. And actually that is actually in my final recommendation, which I will give on the way forward.
Thank you. Any other honorable member? If no response, I want to ask you to give your final recommendation.
Thank you, Honorable Chair. Honorable Chair, from what has transpired in this session, it is coming out clearly that something needs to be done urgently over this matter in the best interest of the people of Uasin Gishu. I included, being a beneficiary of this medical cover. I would give a way forward by stating that the user department to fully engage with the insurance company through meetings, which will now give a footprint of paperwork on their omission or commission or failure on their part to perform their obligations, which will now form part of evidence that the contract implementation committee will write to the accounting officer that there is material breach on the performance by the service provider, which will now culminate into instructions, and we will take action. So I'll call upon the contract implementation committee to do their work, give us recommendations. For example, if you see the recommendation they gave us, it was almost 4 recommendations. Payment, that they make sure that they appoint a care manager. If in that recommendations they have told us to initiate a legal process, we would have done so. So I call upon the said contract implementation committee to perform their function and report to the office of the county attorney through the accounting officer of any material breach, and we will take action to make sure that the people of this great county does not suffer when they are not feeling well. Thank you so much.
Thank you, honorable members.
I know it was his last submission, Chair.
Yes, you have what?
But because legal will not be appearing again, in the likely event that we terminate this contract, will Uasin Gishu County lose any money?
Thank you, honorable member, through the chair. And that is now, that will take us into a legal risk. The problem with these contracts is that that is why, in the wisdom of the drafters of this contract, we normally call upon the parties to avoid any conflict, because in the fullness of time, we do not want to be taken to court for breach of contract from our part for non-payment. So I would call upon the parties that we exercise caution in terminating this, and we get documentations. Any allegation of breach should be supported by a document, so that when we move to court, we have sufficient evidence. It should not be majorly emotional. And nothing stops us. We better, even if it is a court case,
Chairman,
it is for the future.
Chairman,
So that going forward, the service providers should not think or appear to believe that we cannot move to court.
Chairman,
Your final submission, Honorable Member. Has it invited you to?
He has invited wrath from this side, Honorable Chair, that what is happening in Uasin Gishu now is rather very emotional. What is happening in Uasin Gishu, Honorable Chair, I am a witness. I have seen families agonize when trying to find interventions in terms of health to their loved ones. It is painful, it is emotional, and sitting here, Chairman, as a representative of the people, we need actions now. When the lawyer tells us that let us exercise caution in how we deal with these people.
Honorable Member, I hope he was referring to diligence so that we not miss out on something and we are pinned down.
But again, Honorable Chair, we are bound by timelines in this case, Honorable Chair.
Thank you.
We have patients here in Uasin Gishu who wants to be assisted medically in the biggest facilities here in Uasin Gishu. Remember, Uasin Gishu County is an equal opportunity provider. Chairman, you cannot subject the residents of Uasin Gishu to see the hospital. You cannot subject employees of Uasin Gishu to some clinics here in Uasin Gishu, Honorable Chair. I am asking you, Chair, that you find him out of order by saying that let's not be emotional. We need to be very emotional and in fact act with a lightning speed to salvage the situation.
Thank you.
And I'm asking this, Honorable Chair, and he should respond to this.
No,
that is it possible,
through me, Honorable Member.
Through you,
yes.
Honorable Chair,
Through
my,
Chair,
my
not me.
my able Chair,
Through the Chair.
through you, Chair.
Yes.
Is it possible that we terminate this and then walk the reverse? But first, let us realize that we have a cause to terminate.
Yes.
Is there a breach of contract? If we all agree that there is a breach of contract, then we terminate and then we sort it.
Thank you, Honorable Member. Your concerns has been heard, Honorable County Attorney. There is the phase at which there is that between application for breach of contract in court and the determination of the case. What happens in between that time for the patients and for the workers of Uasin Gishu? What happens once there is filing of a case for termination and up to the date of determination of that case? What happens to the people of Uasin Gishu?
Thank you, Honorable Chair. I believe that will be that is an area of great concern to every party. That upon a dispute arising, the users of the said medical cover might be exposed during that time because a mechanism actually should be provided that during that period there should be subsidiary or some sort of supplementary cover of which it can be obtained in form of a court order, but I cannot speak heavily on that matter because it's a judicial process. But I believe that when there is such a scenario, there will be exposure because relationship would have been tempered.
Thank you. Honorable members, I want to thank everyone for this evening sittings. It is coming, as said by the County Attorney, that material content in evidential giving is important. And in the morning, we saw Trident very mean with information and with documentation. I think that they are also being cautious on being evidential. So, honorable members, this meeting stands adjourned until later date. Thank you, and God bless you. Sergeant at Arms, you can assist the county attorney, and the members remain seated for housekeeping.